I would like to welcome you all to our online briefing on the human rights implications of the Supreme Court of the United States decisions in the 2014 term. I would also like to thank our presenters and the rest of you all for taking time out of your busy schedules to join us today. This event is being recorded, and the recording will be available on YouTube and on our website immediately after the event today. My name is Lauren Bartlett, and I'm the Project Director of the Local Human Rights Lorien Project here at the Center for Human Rights and Humanitarian Law at American University Washington College of Law. I'll be moderating the video briefing today. The Local Human Rights Lorien Project works to normalize human rights at the local level here in the U.S. by providing training, coaching, and resources to legal aid attorneys to integrate human rights into their daily work. The Center provides scholarship and support for human rights initiatives around the world, working with students, academics, practitioners to enhance the understanding and implementation of human rights and humanitarian law domestically, regionally, and internationally. We hold regular events and trainings, some of which are online, like this one, for practitioners and law students. Please visit our website for a list of upcoming events. Our website is www.wclcenterforhr.org. In terms of what's going to happen today, each of our panelists will speak for approximately 12 to 15 minutes. Professor Robert Dinerstein will speak first about the disability rights implications of the Hall v. Florida decision. Next, Teresa Kaufman will speak about the implications of Bond v. U.S. on bringing human rights home and the use of human rights law in local and state courts. Lastly, Katrina Anderson will speak about reproductive rights and the implications of Sebelius versus Hobby Lobby decision. Though there has been a great deal of news about the Hall, Bond, and Hobby Lobby cases, there's been very little discussion about the human rights implications of these decisions. So I'm going to provide a brief bio for each of the speakers, but please refer to our website for links to their full biographies. Also on our website, you'll find a link to each of the Supreme Court decisions that we'll be discussing today, as well as the amicus brief filed by the Center for Reproductive Rights in the Hobby Lobby case, as well as PowerPoint presentations. Professor Dinerstein's presentation is already up on our website. We hope to share the others with you later. So again, our website for your reference is wclcenterforhr.org. Please feel free to submit questions at any time during the presentations, and there are 3 ways to submit questions. The first is through the Q&A Google Hangout button, which is you can find through the portal there on the video. You can also send questions by Twitter using hashtag SCOTUS 2014 or by email to wclcenterforhr@gmail.com. But note that we will not be addressing your questions until the end of the call or the briefing at approximately 12:45, 1 p.m. And also, given if there are a large number of questions, we may not be able to get to all of your questions, but we'll take them on a first-come, first-served basis. If any of you would like more information on using human rights law in the U.S. and how to make human rights arguments before U.S. courts and policymakers, please download our Local Human Rights Lorien handbook, which is available on our website. You can also refer to the Bringing Human Rights Home Network's website, which is available at the Human Rights Institute at Columbia Law School. There's good information on our website as well as the Bringing Human Rights Home Network's website. All that said, I'm now going to introduce our first presenter, Professor Robert Dinerstein. Professor Robert Dinerstein specializes in the fields of clinical education and disability law. In 2005, Professor Dinerstein founded the Disability Rights Clinic at American University Washington College of Law and has served as its director since. Internationally, he has consulted in Ghana and Malawi regarding the revision of mental health laws and was a signatory to the Montreal Declaration on Intellectual Disabilities. He has also consulted regarding disability rights clinics and courses in Latin America and Africa. With the Center for Human Rights Executive Director Hadar Harris, he runs our Disability and Human Rights Fellows Program, which receives support from the Open Society Foundations. Thank you so much, Professor Dinnerstein, for joining us today to discuss the Hall v. Florida decision. And just one note, I wanted to let everyone know we're live tweeting the event at HumanRTS on Twitter, HumanRTS. So thanks again, Professor Dinnerstein. I'm going to hand it over to you.
Okay, thank you, Lauren. Can you all see me? Good afternoon and welcome to this briefing. I'm going to, in a moment, just move to a PowerPoint. So you're going to see the PowerPoint slides and not see me, which is probably to the advantage. So with that, let me go to that. Okay. So I've been asked to speak about the Hall versus Florida decision, a decision about the meaning of the Eighth Amendment, and a Supreme Court decision that was decided on May 27th of this year. It was a 5-4 decision with Justice Kennedy writing the majority opinion, joined by Justices Breyer, Ginsburg, Kagan, and Sotomayor. Justice Alito wrote a dissent, which was joined by Chief Justice Roberts and Justices Scalia and Thomas. What the court did was to reverse the judgment of the Florida Supreme Court, which had interpreted Florida statute to preclude consideration of a defendant's intellectual disability if his score was, an IQ score was above 70. As the court said in Hall, this rigid rule creates an unacceptable risk that persons with intellectual disability will be executed and thus is unconstitutional. Florida and other states, according to the Supreme Court, must take into account something called the standard error of measurement, or SEM, in determining what an IQ test score means, as itself part of the determination of the intellectual functioning component of determining whether someone has an intellectual disability. States like Florida must take into account professional judgments about what IQ scores mean, and those judgments underlie the legislative policies and inform the court's view of what is cruel and unusual punishment under the Eighth Amendment, under our standard of evolving standards of decency. I'm not going to go into a lot of detail on the statistics. As we like to say in law school, many people went to law school to avoid having to do math, but a little bit of it will be necessary so you can understand what the court's decision was really about. This case is significant for a number of reasons. One of them is that it extends the meaning of the Atkins versus Virginia case, a Supreme Court case from 2002 that banned the death penalty for people with intellectual disabilities. Atkins, by its terms, left open to the states how to implement the ban. In this case is really one of the first ones trying to determine what the nature of that delegation to the states was and what the limits might be on it. It's also important to identify the role of professional standards and interpretations of those standards for courts. It reflects a greater understanding of intellectual disability than we've seen before from the Supreme Court, although, as I will say later, not a perfect understanding. It may suggest the possibility of extending the ban on the death penalty in the United States to other groups, in particular people with severe mental disorders. And finally, it raises questions that have come up with regard to the Convention on the Rights of Persons with Disabilities, that is the CRPD, of whether specific rules, even that favor people with disabilities, are consistent with a rights-based view of disability law, and particularly with non-discrimination. And I'll talk a little bit about that at the end. Of course, with respect to human rights more generally, the death penalty is of major importance in thinking about human rights. There's a growing consensus around the world that the death penalty should be abolished for all, and even in those countries like the United States that have not abolished it, urging that the United States and other countries that still have the death penalty move toward limiting its use, including moratoria against its use. So this case, I think, is part of that evolution and development. Briefly about the facts, of course, it's a death penalty case, so the fact that some level of the crime are horrendous. Freddie Lee Hall was found guilty with another defendant of murder, kidnapping, and rape of a woman. They then left the scene of that crime, went to a convenience store. In the parking lot of a convenience store, a sheriff was killed as well, so there were two murders in the case. which formed the basis of the charge of death against, charge of murder and other charges against Mr. Hall. Freddie Lee Hall's upbringing is similarly horrific. The case, the court opinion includes discussion of various beatings that he underwent as a child. His family did not accept him as a person of limited abilities, and instead, in a sense, blamed him for that, and he was repeatedly subjected to not only beatings but quite arbitrary and bizarre ones at that. There was a concern as he was growing up that he might not have typical intelligence. Consequently, he had many IQ tests over the course of his life. I think the court points out there were 9. Scored as low as 60 on some of those, as high as 80 on others. For technical reasons, the courts below did not consider any scores under 70, so the case came to the Supreme Court on the basis of scores that were at least 71 or higher. The sentencing jury in this case determined that Mr. Hall should be put to death. The sentencing court at the trial court level accepted that and has a quote that I include here. Nothing of which the experts, and these are experts who talked about his limitations and that he had an intellectual disability, nothing of which the experts testified could explain how a psychotic, mentally retarded, brain-damaged, learning-disabled, speech-impaired person could formulate a plan whereby a car was stolen and a convenience store was robbed. And I will simply say briefly that that kind of litany of limitations and the supposed inconsistency of those limitations with the ability to carry out a crime is one of the, I would say, false conclusions sometimes that people make about people with disabilities. That Mr. Hall had an intellectual disability does not mean that he didn't have other abilities, and he and others in a similar situation. And so the fact that you might be good at sports, you might be good at public speaking, you might be very good at mechanical skills and tasks is not inconsistent with having an intellectual disability. The problem, as the Supreme Court saw it, was not only that Florida established this bright line of a score of 70. If you were 70 or above, you did not have an intellectual disability, according to the Florida court. But also, that determination cut off any further inquiry into adaptive functioning, which is an important part of the definition of an intellectual disability. By the way, intellectual disabilities essentially requires 3 things. A determination of significantly limited or sub-average intelligence, typically measured by an IQ score of at least 2 standard deviations below the mean. Secondly, significant limitations in what's called adaptive functioning, the ability to carry out tasks that are important in one's daily life, and that both of those conditions arise during one's developmental period before the age of 18. I won't go back to the 18 because that's not in dispute here. Whatever happened to Mr. Hall happened during his developmental period. In a way, you can't understand Hall without knowing a little bit about Atkins, and for reasons of time, I won't go into great detail about that, except to say that the Atkins court in 2002, the Supreme Court, decided that it was cruel and unusual punishment to execute people with intellectual disabilities based on 2 basic rationales. One, that states were increasingly moving towards banning the death penalty for such people. If you added the states that didn't have the death penalty plus the states that in fact specifically excluded people with intellectual disability, you had a very strong consensus moving in one direction to ban this. And then secondly, the very nature of the condition itself was consistent with this ban. That people with intellectual disabilities have, by definition, somewhat of a diminished capacity to understand and process information, to communicate, to think abstractly, to learn from experience, to be logical, and to control their impulses and understand reactions of others. There's a characteristics of more or less degree that anyone with an intellectual disability will have. And having those characteristics makes it less justifiable to pursue the traditional criminal justice goals of retribution and deterrence. Essentially, those goals can't be served. Disabilities are more prone to give false confessions, sometimes because they're quite suggestible and quite deferential to authority. They often make poor witnesses in their own behalf. Their demeanor at trial may look as if they do not care about the circumstances, as opposed to, and therefore, in a sense, might be psychopathic. And they're less able to help their lawyers in their cases. The court did not in Atkins say that people with intellectual disabilities could not be subject to criminal liability, could not be prosecuted, convicted, and sentenced. It simply said they could not be put to death. There is a footnote in the Atkins decision that looks to the international community's view of the use of the death penalty with this group, and that footnote 21 in the majority opinion was met with certainly a certain criticism and indeed a level of derision on the part of the dissenting opinions by Justice Rehnquist and Scalia, who were not inclined to rely on international law at all. Atkins left open issues of how to implement its ban on the execution of people with intellectual disabilities, and Hall is one of the cases that looks at that issue. Okay, so what was the problem with what Florida did? The court said that it disregards established medical practice. Again, it's not a medical condition, but that's what the court said here. By taking the IQ score as conclusive without looking at other issues, and by not recognizing that any IQ score is itself a kind of approximation. What do we mean by that? Any test, a standardized test, psychometric test, reflects in a sense a judgment of accuracy that can vary, and it can vary. Any particular test score can vary because of variations you see here on the screen: the examiner's behavior, the test performance variation, how cooperative the test taker is, and other factors. Because of that, the people who study this, the psychometricians and others, would say that instead of any one precise score for an IQ test or another kind of standardized test, we need to think of a range. And we think of a range and we think of a confidence level. So when we talk about a IQ score of 71, we really need to say that a score of 71 is really a score within which we have a 68% level of confidence that the true score is somewhere between about 68.5 and 73.5. If we wanted to go out to a 95% level of confidence, we would say 95% level confident that the score is between 66 and 76. It just means that you can't reduce the IQ to a one-number score, just like the LSAT or the SAT or other scores that you might be familiar with. For Florida to do as it did, to define IQ with an absolute cutoff, is inconsistent with how these tests are really understood and measured by the people who derive them and interpret them, and that's where part of its problem was. The court did its own math. I won't show my work with this, but essentially concluded that about 41 states would not allow a kind of automatic bright line rule of 70 to conclude that someone did not have an intellectual disability.
Hey, Professor, sorry to interrupt. We are not seeing your slides advance. So maybe if it's not functioning, maybe just have the camera go back to you. But I just wanted to warn you that we're not seeing the slides advance.
So what slide are you seeing right now?
Just the first, the introductory slide.
Oh my goodness. Okay. I'm sorry that that's happening. Let me see.
Just wanted to let you know.
Okay.
Oh, there we go. There. Now we can see it.
Now you can see the. It says States Incorporation of SEM?
Yes, yes.
Okay. All right, so let's see. How about now? Did that move?
Still States Incorporation of SEM.
Okay, so what
Now it moved. Field T towards Atkins.
Okay.
But it's okay. Just keep going. I just wanted to let you know.
No, I appreciate that because that'll let me know what folks are seeing. The Supreme Court went on to say that even though Atkins deferred to the states to implement what the constitutional interpretation of the restriction was, the states did not have unfettered discretion. In other words, what the states could not do was to define intellectual disability different from the way the professionals in fact defined it. Once the court went on to say that once the court concludes that there's a state-based consensus against using the death penalty in this way, and once it concludes that the professional expertise supports that, those two determinations inform its own view that executing people with an IQ of 70 or above without more would be inconsistent with evolving standards of decency and therefore violate the Eighth Amendment. So it's important to understand in this jurisprudence that it's not just a kind of a totaling up of the score, but it's also the court's its own judgment, its independent judgment that this is the way to go. The court concludes its opinion by saying that the death penalty is the gravest sentence our society may impose. Persons facing that most severe sanction must have a fair opportunity to show that the Constitution prohibits their execution. Florida's law contravenes our nation's commitment to dignity and its duty to teach human decency as the mark of the civilized world. The states are laboratories for experimentation, but those experiments may not deny human dignity the Constitution protects, and that's its conclusion. As I noted, there is a dissent by Justice Alito. He believed that the Hall case is a departure from Atkins because it relies less on what the states say than the views of professional associations, and he thinks that's inappropriate to do. He would do the math differently and believes that there actually aren't 41 states against the use of the bright line rule, and that's kind of a little bit in the weeds here, but he disagrees with how the majority came to its conclusion. Because he thinks there is no methodological consensus of how to interpret intellectual disability, he concludes that Florida can't be said to have violated the Constitution. He also thinks the court doesn't understand SEM, although I think his own opinion reflects that he understands it even less. And with regard to reliance on professional views, he points out that views can change, that as views change, courts would have to reassess the new view to see whether it's still consistent. He raises the question of, well, which groups do you defer to, and finally says that the purpose of determining IQ, in this case criminal justice purpose, may be different from the purpose in other cases, such as eligibility for services. Winding this up, I wanted to mention a couple of other things. One thing that advocates have pointed out is that the court, early in its opinion, says that it is adopting the term intellectual disability in lieu of the former term of mental retardation. This reflects belatedly an understanding of the change in terminology, which I think everyone thinks is positive. The court says that intellectual disability is a condition and not a number. That's also good. On the other hand, the court does use from time to time terminology that says that people who suffer from intellectual disability, making it sound like it's a medical condition. The dissent actually does this more often. And by my count, there are at least 23 references in the majority opinion to the views of the medical community, to medical diagnosis, to psychiatric concerns. And this is inconsistent, these use of medical terminology really, is inconsistent with the social model of disability, and the CRPD is a real good recent example of the value of and importance of the social model generally. So by continuing to stay in the medical world, the court reflects that it hasn't quite evolved as much as others have. There is an issue that I alluded to at the very beginning about whether having a disability-based exclusion, in this case from the death penalty, is consistent with the CRPD. There are some who have urged, including the High Commissioner, that, for example, an insanity defense is not based on disability, would not be consistent with the CRPD. That's not everyone's view, but it is the view of some. A big part of the CRPD is the emphasis on legal capacity of people with disabilities, that everyone has legal capacity, and some have raised the question as to whether excluding people with disabilities from the death penalty is consistent with that view that everyone has legal capacity. It raises for me the question of whether it's ever appropriate to consider disability as a factor in any kind of social practice, and my own view is it is when it directly relates to conditions that are part of the disability. And finally, some have said, well, perhaps some reasons for the death penalty is being problematic. That is, reasons having to do with level of representation, the concerns with false confessions, ability to help counsel, are more reasonable to rely on than what might be called the inherent limitations of people's moral reasoning, which troubles some individuals. As I said earlier, whether or not this case will be extended to people with severe mental disorders is one of the outstanding issues that's there. Finally, I would just conclude by saying I think the human rights implications of this case are clear. The death penalty, to the extent it continues to exist in some number of countries, remains a human rights issue of great importance. Of course, remains an important issue domestically in the United States. Just today, the papers reported that California, a lower court, banned the use of the death penalty in California on other grounds, including the delay in which the death penalty gets actually put into practice in California. So this question of how this relates to human rights is very important. Also, the notion of human rights norms as evolving. And in our jurisprudence under the Eighth Amendment, which is based on whether the so-called evolving standard of decency, the question gets raised, who determines what the standard of decency is? And is that simply a matter of domestic understanding and domestic law in the United States, or should it be looked at in a broader way in terms of the international community? I think with that, I'll conclude. I'm sorry you didn't get to see the movement of the slides, as it were, but again, the PowerPoint is loaded on site, so you'll be able to see that. Thanks a lot.
Thanks so much, Professor Dinnerstein, for your presentation. And I wanted to now introduce Risa Kaufman. Risa is Executive Director of the Human Rights Institute at Columbia Law School and a lecturer in law. At the Human Rights Institute, she works to develop and advance international human rights norms and strategies in the United States through research, advocacy, network building, and training, and oversees the overall functioning of the Institute. In addition, Ms. Kaufman supervises students in Columbia Law School's Human Rights Clinic and teaches a seminar on domestic human rights advocacy. Thank you so much, Ms. Kaufman, for discussing the Bond versus U.S. decision with us today.
Great. Thank you, Lauren, and the Washington College of Law's Center for Human Rights and Humanitarian Law for organizing this briefing and for inviting my participation. So as Lauren mentioned, I'm going to be talking about Bond versus the U.S., which the Supreme Court decided on June 2nd. I also have a PowerPoint, which, against my better judgment, I will try to use. Okay, and hopefully this will work. So Bond versus the U.S. is significant for human rights because it raised important questions about federalism and international treaties. Specifically, the case potentially called into question Congress's ability to enact legislation implementing international treaties that touch on issues that are traditionally within the jurisdiction of state government. So the short story is that the majority opinion in Bond avoided the constitutional question and instead held that the conduct that was at question didn't fall within the scope of the statute at issue. But of course, there's always a longer story. So the facts of the case. They read something like a soap opera. When Carol Bond, a microbiologist, learned that her close friend, Merlinda Haynes, was pregnant and that Bond's husband was the father, she spread toxic chemicals on the friend's car door, mailbox, doorknob, and other places. Haynes wasn't seriously injured by any of these attempts since she was able to notice the chemicals, and she couldn't persuade local law enforcement to act, so she contacted the U.S. Postal Inspectors, who captured Bond on video stealing her mail and placing the chemicals on Haynes' car muffler. So the federal government prosecuted Bond for mail theft and also for violating the Chemical Weapons Convention Implementation Act, which Congress had enacted to implement the International Convention on Chemical Weapons. The U.S. ratified that convention in 1987. The government charged Bond with violating Section 229A of the Act, and you can, hopefully, you can see the text of that here on your screen. So Bond challenged her prosecution on grounds that it fell outside the scope of the Act and the intended scope of the Chemical Weapons Convention. She also argued that if, in fact, the prosecution did fall within the scope of the Act itself violated the 10th Amendment and constitutional federalism limits on Congress's authority to enact legislation implementing a treaty, because the Act touches on traditionally local concerns. So the case offered the justices an opportunity to revisit the court's holding from 1920 in Missouri versus Holland, that if a treaty is a valid exercise of the federal treaty power, resulting implementing legislation is valid pursuant to the necessary and proper clause.
Hey, Risa, I just wanted to let you know that your PowerPoint is also not advancing, so maybe just good to switch the camera back to you, or just assume that nobody can see anything but the first title page.
Okay.
Sorry. So sorry.
Really unfortunate. Okay. What if I do it this way? You know what? I'm going to do it like this. Is that better?
We can see the slide now. It's a quote about ambiguity.
Okay, we'll do it that way. So in an opinion written by Chief Justice Roberts and joined by Justices Kennedy, Ginsburg, Breyer, Kagan, and Sotomayor, the court did not revisit the court's holding in Missouri versus Holland. Rather, the court first noted an ambiguity in the scope of the Chemical Weapons Convention Implementation Act, namely the improbably broad reach of the key statutory definition that was given to chemical weapon. And then it turned to what it characterized as the well-established principle that courts must find that Congress intended to override the traditional state-federal balance before construing an otherwise ambiguous statute. Next, Lauren, did that advance?
We can see it's about a clear indication.
Great. Okay, so we're going to do this. Right. Next, the court found that there was no clear indication that Congress intended for the act to cover what it characterized as Bond's purely local crime. And in doing so, it considered the ordinary natural meaning of the term chemical weapon, including its dictionary definition, and determined that in using the term, Congress didn't clearly intend for it to have such an expansive scope that it would reach Bond's conduct. So the result is the court engaged in statutory interpretation to reverse Bond's conviction under the Chemical Weapons Act, and in doing so, it avoided ruling on the question of whether the act itself violated constitutional federalism limits on Congress's authority to enact legislation implementing a treaty touching on traditionally local concerns. Of course, that's not the end of the story. Justice Scalia issued a concurrence joined by Justice Thomas and in part by Alito. In it, he criticizes the majority's statutory interpretation as being results-driven, and he makes clear that he would have held that Congress indeed overstepped its authority under the Necessary and Proper Clause. Scalia would have found that Bond's actions fall within the scope of the act, but that the act itself was unconstitutional because it exceeds Congress's authority. So presumably, Justice Scalia would have revisited Missouri v. Holland and not allow for wide subject matter jurisdiction pursuant to the Necessary and Proper Clause. Justice Thomas also filed a concurrence in which he laments the fact that the court didn't have the opportunity to reassess Congress's treaty-making power altogether, and he questions whether the treaty power can be used to regulate purely domestic affairs. Justice Alito also filed a concurrence in which he basically restates Justice Thomas's opinion that the treaty power is limited to matters of international concern. But Justice Alito would hold that because Bond's convictions fall outside the scope of the treaty and the statute's attempt to regulate such conduct isn't necessary and proper to execute the treaty. So it's not a valid exercise of Congress's power. So from the majority and concurring opinions, we can glean that while all 9 justices concurred in the judgment to reverse Bond's conviction, 6 did so on statutory grounds. 2 of the justices would have adopted a much more constrained reading of the Necessary and Proper Clause regarding Congress's authority to enact implementing legislation. 3 would have considered imposing limits on the treaty power, but none of the justices seemed to support an unlimited treaty power or wrote to defend Missouri v. Holland. Indeed, none of the court's more liberal justices wrote separately in the case. So here, hopefully, you see one of the concluding paragraphs from the majority opinion. The opinion can certainly be read as another strong statement by the court about the need to preserve federalism, even though it doesn't touch on the treaty power more generally. It is broadly consistent with the court's vigilant policing of federal authority vis-a-vis the states. So, what are the implications of the decision for human rights advocates? Why are we talking about it today? Understandably, many human rights advocates might be concerned about the court's curtailment of federal authority over what it deems to be local issues. But we can draw on the opinion for positive support for human rights in the U.S., namely to support human rights treaty ratification. Advocates can point opponents of treaty ratification to the case to show that Congress won't let, that the court won't let Congress overreach through its power to implement treaties, which you could argue could help smooth the way for ratification of things like the Disabilities Convention and CEDAW. And in fact, many treaty advocates are hailing the decision as a green light to the Senate to move forward with the Disabilities Convention, or the CRPD. You'll recall that when the Senate failed to provide consent to U.S. ratification of the CRPD when it came to a full Senate vote in December 2012, the Senate Foreign Relations Committee revisited the treaty at a hearing in November 2013, and by Odd coincidence, at the same time across the street, the Supreme Court was holding oral arguments in Bond. So naturally, the confluence placed this case at the center of the hearing, with some of the senators suggesting that the Senate postpone its consideration of the treaty until the court issued its decision. And now advocates can point to Bond as a strong indication that Congress can't and won't use the treaty power as a way to run roughshod over the states in the name of treaty implementation, as Senator Mendez, who chairs the Senate Foreign Relations Committee, did on the day that the decision was issued. Another upshot for human rights advocates is that by vigorously preserving the traditional federal-state balance, I would suggest Bond also underscores the continued important role that state and local governments play in implementing the U.S.'s human rights treaty obligations and the need for advocates to encourage them to do so. So is the constitutional issue, or are the constitutional issues behind us? There was certainly a lot of anxiety and many dire predictions about how the court would rule on the constitutional question of Congress's authority to implement treaties under the Necessary and Proper Clause and the treaty power more generally. The majority opinion in Bond doesn't resolve the issue, but most commentators would agree that it's unlikely to be put so squarely or neatly before the court again in the near future. This is in part because Congress often has other grounds for implementing treaty obligations and doesn't need to rely on the Necessary and Proper Clause. It can often rely on the Commerce Clause or, as amicus had argued in this case, the Define and Punish Clause. It's notable that the Commerce Clause did not come up here because the government had stated at an earlier phase of litigation that Congress didn't rely on the Commerce Clause as a basis for enacting the legislation in Bond. So the bottom line from Bond, the court avoided the constitutional question of the scope of the treaty power and Congress's power to implement treaties pursuant to the Necessary and Proper Clause. Nevertheless, the decision is a strong federalism decision decided on statutory interpretation grounds, which treaty advocates can point to as a green light to the Senate to move forward with ratification of human rights treaties, and it underscores the importance of state and local government implementing U.S. treaty obligations. So I will end there, and I'm happy to take questions later. Thanks so much.
Thank you so much, Risa. And just to let everyone know, this is the first time we're using this technology, and despite our practice session yesterday, we're all getting used to this. And thank you to our speakers and to our viewers for hanging in there with us and figuring this out. I'm going to go ahead and introduce our next speaker. Katrina Anderson is Senior Human Rights Counsel with the Center for Reproductive Rights, where she leads the center's work to integrate international human rights into domestic legal advocacy through a variety of strategies, including human rights documentation, amicus briefs, state and federal policy advocacy, and reviews of U.S. treaty compliance. She currently leads Nuestro Texas campaign, which focuses on eliminating barriers to reproductive health care for immigrant women living on the U.S. border of Mexico. Katrina received her LLM in International Legal Studies from WCL. Thank you so much, Katrina, for discussing the Sebelius versus Hobby Lobby decision with us today.
No problem. Thanks, Lauren. And thank you to WCL and to all of you who are joining us this afternoon. So much has been written about Hobby Lobby, including probably, I suspect, by many people who are on this call, because it raises so many new questions, not only about women's rights and access to contraception, but also how religion could be used to erode protections from discrimination under U.S. law, and of course, questions around corporate personhood. I'm going to give an overview of the main holding and discuss why this case raises human rights concerns, and also explain how the majority departed from international human rights standards as they concern access to contraception and reproductive rights. So I'm focusing more narrowly on that set of rights as opposed to all of the broader rights that are at issue in this case. And I also should mention, as Lauren said in the beginning, that the Center for Reproductive Rights co-wrote an amicus brief in this case with the law firm Morrison & Forster, as well as Professor Noah Novogradsky from University of Wyoming School of Law. The lead amicus was Professor Lawrence Gostin from Georgetown. And I'll be drawing on a lot of those arguments for this analysis, even though, of course, unfortunately, I must concede that the majority didn't find them too persuasive. But we still believe that they are international law and should be given consideration. So I am also, like the others, going to attempt to do a PowerPoint. Let's see if this works. Okay. So the Burrell versus Hobby Lobby stores, it's now Burrell, it was Sebelius, and was joined with Conestoga Wood Specialty Store versus Burwell. This was a 5-4 decision that was written by Justice Alito. There was a concurrence by Justice Kennedy and a very strong dissent by Justice Ginsburg, which was joined by Justices Breyer, Sotomayor, and Kagan. There was also a separate dissent by Justices Breyer and Kagan. The central holding of this decision was that, let me just try and see if I can, hold on a second. I'm going to try and move through these slides. There we go. So the central holding of this decision was that, as applied to closely held corporations, Department of Health and Human Services regulations enforcing the Affordable Care Act contraception mandate violate the Religious Freedom Restoration Act, otherwise known as RFRA. So a little bit of background here. The HHS regulations at question in this case were promulgated to enforce the Affordable Care Act, that requirement that employers' health insurance include preventive care and screenings. So this is a package of essential health benefits that included all FDA approved forms of contraception without cost sharing. The challengers in this case were two for-profit corporations. Hobby Lobby is a craft store, and Conestoga Wood is a cabinet making company. And as the court described, they had, quote, sincere Christian beliefs, the owners did rather, believing that 4 forms of FDA-approved contraception were tantamount to abortion and therefore violated their religious beliefs that life begins at conception. The challengers relied on RFRA, which is a federal law that provides protections for religious believers beyond the First Amendment and requires the federal government to justify laws that arguably impose burdens on religious beliefs. And these two cases were 2 of almost 50 similar cases brought by for-profit corporations. So the direct result in this case was that closely held corporations can deny their employees insurance coverage for certain forms of FDA-approved birth control. The court held that the challengers had standing under RFRA because it decided that closely held corporations should be considered persons under the Act. So closely held corporations are defined as corporations where most of the shares are privately held by a small group of owners and stock is not usually publicly traded. So the implications of this are that corporations whose purpose are secular do not have to comply with the generally applicable federal law that protects employees. The court held that the HHS contraceptive regulations substantially burden the owner's exercise of religion. Therefore, because the corporation's owners have sincerely held beliefs that 4 methods of contraception, including IUDs and emergency contraception, are abortion, the regulations infringe on their religious beliefs by requiring them to provide contraceptive coverage in employee health plans. The court found that all available alternatives were too burdensome, including economic penalties such as paying $200 per employee, which is less than the average cost of providing insurance, actually. But the court found that the corporations have religious reasons for providing insurance to employees, and so this alternative was unacceptable. The court, what's significant here also is that it was enough to the majority that the belief was sincerely held. So they disregarded the consensus of the medical community that the forms of contraception at issue do not constitute abortion. These drugs work by blocking implantation of a fertilized egg. The failure of the court to examine this evidence is pretty troubling and of course opens the door to many questions about how much the court will defer to the religious beliefs that are fervently held rather than grounded in fact. So third, although the court acknowledged that guaranteeing cost-free contraceptives serves a compelling government interest, it found that the government's method of furthering this interest was not narrowly tailored. One way of furthering the interest without violating plaintiffs' rights, according to the court, is for the government to assume the cost of providing contraceptives. Another would be to allow for-profit corporations to use the same accommodation that's currently provided to nonprofit religious organizations. The court was clear that these alternatives would not comply with RFRA for purposes of all religious claims, which of course leaves many unresolved issues. The same week, the court appeared to undermine its own reasoning when it issued an injunction allowing Wheaton College not to fill out a form expressing its religious objections to the contraception mandate, and this was the accommodation for religious nonprofit organizations that the court had found to be a less burdensome means of furthering the government's interest. I just also will note that the court did not reach the First Amendment claim in this case because it decided the matter on statutory grounds. Okay, moving to the dissent. The dissent characterizes this as a decision of startling breadth because it, as I mentioned, appears to raise far more questions than it answers. I'm going to simplify Justice Ginsburg's dissent for the purposes of time, but I'll just go through 3 quick points. First, in contrast to the majority, she emphasizes the harm to women. She starts by quoting Planned Parenthood versus Casey in saying that, quote, the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive their reproductive lives. And she notes that this is the very thing that motivated Congress to ensure that preventive services were covered under the ACA. She's very concerned that the court disregards the harm that their religious exemption will pose on women, and is especially concerned about poor women. She says, quote, the cost of an IUD is nearly equivalent to a month's full-time pay for workers earning minimum wage, and that almost 1/3 of women would change their contraceptive method if costs were not a factor. Second, she's concerned that the decision imposes an employer's beliefs on employees. The owners of Hobby Lobby, quote, may decline to acquire for themselves the contraceptives in question, but that choice may not be imposed on employees who hold other beliefs. Working for Hobby Lobby or Conestoga, in other words, should not deprive employees of the preventive care available to workers at the shop next door. And third, she's very concerned about the consequences beyond contraception. She says in a much quoted quote from her dissent, I fear that the court has ventured into a minefield by its immoderate reading of RFRA. So she says that the majority decision suggests the entire contraception benefit could be set aside for a closely held company whose owners object to other forms of contraception besides IUDs and emergency contraception. And indeed, there are currently 40 cases pending in lower courts that will raise this issue. She also points out that there's nothing in the decision to limit the principle at all. So what about a company that didn't want to cover blood transfusions or vaccines due to religious objections to those practices? And last, she's concerned that RFRA challenges could be brought against any number of laws of general applicability. What about laws limiting discrimination on the basis of sex, sexual orientation, gender identity, and race? The opinion doesn't explicitly foreclose this with any legal principles. So human rights law, as Justice Ginsburg's dissent points out, let's start with women's access to contraception as a fundamental right. She says the majority virtually ignores the fact that women have a fundamental right to affordable contraception as recognized by Supreme Court jurisprudence, as well as international human rights instruments and institutions. Foreign courts, international human rights bodies, medical organizations have all recognized that access to affordable contraception is a fundamental component of women's liberty, dignity, and equality. The U.S., through our sustainable development commitments and our foreign policy, has championed the right to contraception. Importantly, the U.S. has also acknowledged that ensuring the right to contraception is consistent with our obligations under International Human Rights Treaty. The Obama administration has pointed to the ACA as a way that we are fulfilling our duties under critical treaties like the ICCPR and ICERD. It's also worth noting that the Institute of Medicine recommendations that informed the HHS regulations recognize the importance of making all forms of contraception available to women. IUDs are a form of long-acting reversible contraception that are highly desirable because they're the most effective. Experts have attributed the decline in unintended pregnancy in the U.S. in recent years to the widespread use of IUDs and other long-acting forms of contraception. So, international human rights law has also said that access to reproductive health care takes priority over a religiously based claim to be exempt from a law of general applicability or to requiring an individual to provide reproductive health care. When balancing these two rights, foreign and international law recognize that there is a limited right to object, but they give priority to women's access to health care. They also carefully regulate the scope of the right to conscientious objection. For example, providers must give notice to patients. They have a duty to refer patients to a non-objecting provider. And in a case of emergency, the need to prevent harm to the patient takes precedence. The provider must perform the service despite their objection. The European Court of Human Rights held in a case called Pigeon versus Sajou that, and this was involving a pharmacist's refusal to dispense contraception on grounds of religious beliefs. The court held, quote, "The pharmacist cannot give precedence to their religious beliefs and impose them on others as justification for their refusal to sell such products." So here, the court did not engage at all with the question of how the employer's religious belief impacts women's access to that right. Simply put, the majority didn't see this as a case balancing rights at all. It saw it as a religious exercise case. I'll just note that our amicus brief argued that international law actually comports with how the court has evaluated free exercise claims in the past. In these cases, the court has considered whether the exemption would burden others, and when it has upheld the exemption, it's done so where the religious freedom did not, quote, bring these rights into collision with rights asserted by any other individual. And this is something that the Ginsburg dissent brings up as well. So third, direct involvement is required. Under international law, the right to object to providing a service is only available where there's a close connection between the person who holds the duty to perform the service and the conduct that violates his or her moral or religious beliefs. So in practice, this means that other countries grant the right to object to those who are directly involved in providing the medical service at issue, which is, of course, usually abortion and rarely contraception. The court explicitly rejected a similar argument that the government made, that the connection between the employer's action, which is paying for an insurance plan, and the action that offended the religious beliefs of the employer or taking contraception was too attenuated. The government had argued, and the dissent agreed, that the focus should be on the employee, who is the one who chooses the plan and takes the contraception. But the court pivoted away from this question by saying that the real issue at this case is whether the contraception mandate imposes a substantial burden on the party's ability to conduct business according to their religious beliefs. And fourth, international law says that only individuals have the right to object, not institutions. In our survey of international and foreign law, other jurisdictions have explicitly rejected an institutional right to conscientious objection because it could interfere both with women's rights to access and the rights of employees working for that corporation. Countries as diverse as Colombia, France, Denmark, New Zealand have all rejected claims by institutions, and in those cases, the plaintiffs were nonprofit institutions. We couldn't find a single instance of a court or an international tribunal allowing an objection by a for-profit corporation, particularly when it concerned insurance coverage for contraception. I thought that this audience might be interested in just knowing as well that there was an opposition law brief that relied on international law. So these international legal arguments are being made on all sides of cases now at the Supreme Court. This was a brief that was filed by Brigham Young University law professors on behalf of various amici, all others I think were outside the US. They were mostly foreign law professors that were affiliated with religious universities. The core of the argument in that brief was that international law gives protection for legal structures that enable the exercise of freedom of religion. I'll just read one quote. Religious beliefs practiced collectively may naturally require modern corporate forms, including for-profit ones. Religious rights do not evaporate the moment profit motive is added to the exercise, the moment that profit motive is added to the exercise of religious beliefs. So consequently, restrictions on this idea of collective expression of religion by for-profit corporations substantially burden the free exercise rights of both corporations and owners. The court didn't go this far, but it did pick up on some of the underlying arguments here, even if it didn't cite to the brief or to international law directly. So I just wanted to flag that as a concern. The support that is cited in the brief is very slim. It mostly draws on academic writings rather than decisions by foreign courts or international tribunals. But where it does pick up on those decisions, it really cites them selectively rather than analyzing trends and looking at the broader context. So just in conclusion, I wanted to spend a couple minutes talking about what's next after this decision. There's been a lot of talk about possible fixes. So one is obviously one that the majority decision named itself, which is that the administration could provide the same accommodation to for-profits as to nonprofit religious organizations. In this case, where the employer would opt out of providing contraceptive coverage, the insurer would pick up the cost. And I believe that the Obama administration is exploring lots of different options along these lines. The second possible fix is that Congress could act to amend the Affordable Care Act or RFRA, or it could pass a freestanding bill. In fact, a bill called the Protect Women's Health from Corporate Interference Act was introduced in the House and Senate shortly after the decision. This bill would bar employers from refusing to cover any health care service, including contraception, guaranteed to their employees and dependents under federal law. However, just yesterday, the bill failed to get the 60 votes it needed to end debate and bring the bill to a floor vote. So it looks like that possibility is dead for now. A couple other just things that I wanted to raise in terms of next steps and implications. Like Ginsburg, I think many people have noted the possible consequences on other rights, most imminently how this decision will impact claims on discrimination based on sexual orientation and gender identity. Religious groups are currently pressing the Obama administration to extend a religious accommodation to employers under an executive order that Obama is about to sign that would prohibit federal contractors from discrimination against employees on the basis of sexual orientation or gender identity. So that's something to watch. And then lastly is just the global implications of this decision are really a cause of alarm for us here at the Center for Reproductive Rights. There's been, over the past several years, a growing concern about the expansion of different countries, recognizing a broader scope of the conscientious objection right, or trying to, and pass legislation along those lines, which has been struck down in courts, as our brief mentioned, but still that effort is advancing. And so we're definitely concerned that this decision will embolden those efforts. For example, in Spain, there's an effort now to repeal a 2010 law that actually had liberalized abortion, and now there's been quite a backlash against that law, and so we're worried that decisions like Hobby Lobby could give momentum to some of those efforts. So I will pause here. It's a lot to digest. Thank you for your patience, and look forward to any questions that you might have.
Great. Thank you so much, Katrina. Thank you, Professor Ditterstein. Thank you, Risa Kaufman. to all of you for your wonderful presentations. We have quite a few questions already and more coming in. I want to let you know we'll be taking questions for the next 30 minutes, and we're going to get through as many as we can. Feel free to use the Google Hangout portal if there's a question and answer part of that application that you can submit questions on. You may also send questions via Twitter using hashtag SCOTUS 2014, or you can submit questions by email to wclcenterforhr@gmail.com. And again, we'll get through as many questions as we can. And for you presenters, I am going to try and post the questions, and I'm taking them in order that we received them. I'm going to post them in the Q&A section so that you can read them along with me in case doing it orally is a little difficult. So the first question we have is, how is the Hobby Lobby holding not choosing any religious beliefs over women's rights? There's actually a couple of questions about the concern about religious beliefs being held over women's rights. Are there other cases where religious beliefs trump the rights to health of a minority group? And this, anyone can answer, although I think this is meant for Katrina.
Yes, I'm just trying to think. I mean, I must admit that I'm not an expert in free exercise cases, and so I'm not really sure if this really speaks to my expertise, because we really were looking so narrowly at the right to contraception and the particular consequences of the Affordable Care Act. I do know that there is another case of a prisoner in Guantanamo who's now is relying on Hobby Lobby for a free exercise claim, and again, like, this decision didn't get to the constitutional issues, but I think they're so closely related to the statutory ones that this is an area where we anticipate further claims arising as under free exercise. But relying on Hobby Lobby to claim that the restrictions against wearing a beard in Guantanamo violate his exercise, free exercise religion. So I'm not, I know that some of these cases are happening, but I'm not sure really how to answer this question, because I think it's just such an evolving area of law.
Great. So my next question is also going to be for you, Katrina. It could be for any of you as well, but there is a real concern that Hobby Lobby could lead to the Religious Freedom Restoration Act being used to permit discrimination against minority groups, including LGBT people. And I think you mentioned this a little bit, Katrina, but if you could speak to this concern a little bit more. And then the other question along with this is, couldn't business owners attempt to use this decision to justify other forms of discrimination?
Yes, I do believe that this is a key worry, and there's been a lot of writing about this, actually. The two instances where it's come up since Hobby Lobby are in the instance of the letter that was written by religious leaders to Obama regarding the executive order about that would prohibit discrimination in federal contracts. And so, you know, Obama has yet to issue that executive order, to my knowledge anyway, and so there's a lot of debate about whether Hobby Lobby should, the scope of that exemption should be applied in this particular case. I also know that the Employment Non-Discrimination Act, which is a pending piece of legislation that's been high on the agenda by LGBT groups for more than 20 years, and contains a religious exemption provision, is also on the table right now, because people, I mean, even though this is a pending piece of legislation and so it's not worked its way through the courts, obviously, there is concern that the way that the exemption is currently drafted will now be too broad in light of Hobby Lobby. And so many of the LGBT groups that have championed this legislation are now retracting their support in light of the Hobby Lobby decision. So I think that this is probably the next area where we'll see cases. I mean, you know, from the Arizona law that was fortunately, there was a bill early this year. I'm sorry, not a law that was fortunately not passed, but there was a lot of debate in the media about whether businesses could claim a religious exemption to refuse service to LGBT people. So this type of thing, I think, is certainly a cause for alarm. There's nothing, as Justice Ginsburg says in her dissent, there's nothing in, there's no legal principle in the majority decision that we see that would limit this, limit the decision just to contraception, despite what the majority decision claims. Lauren, I think you're muted.
You're on mute.
Trying to keep the screen from jumping back and forth between us, but that means I have to remember to unmute myself. For Professor Dinerstein, question for you. You talked about the use of medical and psychiatric diagnoses and language in the decision. What is the difference between the medical model of disability and the social model of disability, and how does that relate to human rights? And I'm going to combine this with another question for you, Professor. Were human rights arguments put before the court in the Hall case, either in the parties' briefs or amicus?
Okay. Thank you, Lauren. With regard to the medical model and social model, basically, the social model of disability, which the CRPD reflects, would say that people have impairments, they have limitations, but whether those are disabling depends maybe less on those particular impairments and more on societal responses to them, so that any determination of disability is really an interaction between a person and his or her environment, which is both the built environment and the attitudinal environment. So, you know, a common example is if someone uses a wheelchair and they are trying to go on the streets of any city, if there are no curb cuts, then they are disabled because they are not able to go up and down the curbs. But if you would have curb cuts, they can go up and down and be able to be mobile in ways that would make them fully able to participate. It's not that the curb cuts cure, if you will, the limitation on their walking, but it just makes it not as limiting. So the social model essentially just says we have to have a contextual view of disability. My concern in the Hall case, in terms of how the court talks about it, is although the decision comes out well from a human rights standpoint, there's still this sense that somehow people with intellectual disabilities are so incapable of some kinds of basic aspects of participating in society that might limit them in other ways. Now, the court wasn't addressing those issues, and I think talented advocates could certainly find ways to distinguish it. But, you know, the fact of the matter is it's sometimes, in the minds of some, hard to distinguish between those rules that we like and want to have applicable to people with disabilities and those that we think don't. And my answer to that is it really depends on the circumstances, and in some cases, disability or the impairment underlying the disability is relevant. With regard to the human rights issues, as I briefly alluded to in my presentation, there are some on the court. Justice Stevens is no longer on the court. He was the one who wrote Atkins. Justice Kennedy and Justice Breyer are more inclined to at least look at international standards, which of course may or may not be the same thing as human rights standards. But there's a strong group that, you know, led by Justice Scalia and certainly including, I would say, Justices Thomas and Alito and the Chief Justice, who are skeptical about human rights norms. And in the particular context of the Eighth Amendment, as I briefly mentioned, the Eighth Amendment jurisprudence here operates under a standard which is somewhat vague but is pretty established in our jurisprudence, and that is that we assess conditions on the basis of evolving standards of decency. What is it considered to be the right standard to assess things? So that although Justice Scalia would say otherwise, most of us would say that things, just because they were okay to do in 1791, are not necessarily okay to do today. So then the question becomes, in human rights aspect, is to what extent should we be looking at not just U.S. standards, but at human rights standards across the world, and of international standards elsewhere. And whether that makes a difference depends a little bit on whether one sees U.S. standards as being consistent with those rules or as different from. In this case, limiting the execution of people with intellectual disabilities, or expanding that limitation, if you will, is certainly quite consistent with worldviews. For many countries, of course, there's no death penalty that's acceptable. So it acts consistently with that. But this is a long way of answering is that no, human rights arguments were not really emphasized, and I think that's partly because of a view that there are too many on the court who would disagree with following them.
Great. Thanks, Bob. And now we've got one for you, Risa. This is from Professor Martha Davis up at Northeastern. Risa's done a good job of putting a positive spin on Bond, but what are folks from the American Enterprise Institute or other rights-oriented groups saying? Have they spun this as a victory, and how?
Well, great question. Thanks, Martha. The answer is I haven't been trolling their blogs. I'm not sure what they're saying about the decision. I mean, the case certainly could be read in many ways. I think the general understanding is that there is concern about the broad scope of human rights treaties touching on issues traditionally with state and local, within the jurisdiction of state and local governments. But I think that this case and the decision does a good job, I think, of trying to assuage some of those concerns. But certainly the issue is still a live issue. I don't think it's going to go away in terms of the scope of the treaty power more broadly, and Congress's power to implement legislation pursuant to the Necessary and Proper Clause. And I'm sure the debate will remain live in the academic literature and within advocacy organizations.
Great. And another question from Martha Davis, this time for Katrina. Katrina, she wants to know if you could comment on the human rights implications of McMullen, sorry.
Good question. So McMullen was the buffer zone case in Massachusetts that the court issued about 1 week before Hobby Lobby, basically striking down a buffer zone that protected access of people seeking reproductive health services, namely abortion, and struck it down on free speech claims. So in that case, McMullen really had the perfect plaintiffs. They had people who identified, two grandmothers actually, who identified as sidewalk counselors, who were not the sort of stereotypical angry anti-abortion protesters. And so, I think that made a huge difference in this case. The holding, although unanimous, was relatively narrow. And Martha, I'm sure actually you could give a much better analysis of this, being that you're from Massachusetts. So, and I know that there's legislation now in Massachusetts trying to address this. I think that the decision will be relatively narrow, and that obviously there are places around the country that have had to re-examine, and some places have even actually decided to drop their buffer zones because in light of this hearing. So I know that the ramifications of it are still being worked out, and I think that they are serious, and we're very concerned about them. My hope is that it's a narrow holding, and that municipalities and state governments will be able to figure out a way to still protect access. And I think that a way that the Massachusetts legislature is doing that, as I understand it, is by saying that the buffer zone can still be in place once there has been a demonstrated incidence of people trying to inhibit access. Like maybe I think it's twice or 3 times, and so trying to I think trying to sort of balance the right to freedom of expression and the right to access reproductive health clinics. So in that way, it's really similar to Hobby Lobby, this balancing of rights. But I do think that in that case, there will be a way to strike a balance that allows for access while also protecting freedom of speech.
Great. I just want to remind everyone you can submit questions to our presenters through the Google Hangout Q&A, through Twitter using hashtag SCOTUS 2014, or by email to our WCL Center for HR at gmail.com email address. We are continuing to take questions. So the next question I have, I wanted to see, we always have an interesting time putting these annual SCOTUS and human rights events together, trying to narrow down to 3 or 4 decisions that we're going to talk about. Were there other human rights implicated decisions that the Supreme Court made this year that any of you would want to comment on? Wasn't quite as exciting as maybe last year with some of the decisions, but there was, quite a few that we had considered beyond the case that Katrina already commented on.
This is. I was going to ask myself like I'm on a phone call. You can see me, but I guess maybe it has a human rights implication. It certainly has a disability rights implication. The Quinn case, where the Supreme Court said that individuals who provide home health care services to people with disabilities in Illinois did not have to pay dues to the public union that was representing them if they disagreed with what the union's activities were. And the reason that is important. It's obviously important for the growth of or maintenance of public employee unions. There's a lot of discussion in the opinion about how the individuals who provide these home services are really employed by the individuals themselves and only sort of secondarily by the state, which kind of made it sound as if these are really almost private arrangements, and it would be unfortunate to require them to participate in union activities. But that really misunderstands, I think, a few things, one of which is the nature of that relationship, where, as in many states, the state provides the umbrella and the funding for these kind of programs, and then they are implemented through the connection between individual employees and the person. But secondly, that this is a kind of employment which is typically underpaid, few benefits, often doesn't attract people who have have high aspirations, if you will, in their careers, and it's changing. One of the reasons it's changing is because of the unionization of these workers, who can, of course, do the kind of bargaining that individuals can't do. And the better, the more education, the more higher salary, the better ability to retain people in these positions, the more it works to the benefit of people with disabilities, who are, in fact, the beneficiaries of those folks. So that was an unfortunate decision. Sort of in the interstices between labor law and disability law that came out late in the term. You're muted.
I'm muted again. Great. Trying to figure this all out. Katrina or Risa, any thoughts on other cases? Not right. Oh, no. You're both muted. Okay, great. Well, at this point, I have, I could ask you a few more questions. We've gone through the questions that have been submitted. If folks on the call have other questions, please go ahead and submit them either through the Google portal, or you can submit them by email or on Twitter. I think I want to thank our presenters one more time for hanging in there with our new exciting technology, new way of doing these online briefings, and for the issues with the PowerPoint and the video. But thank you for being patient with us and for participating and being on camera today, and for your insightful and very informative presentations and great discussion. I want to thank you again before we finish. I think, you know, one of the questions that I have when I was listening to your presentations, and this goes to a lot of the treaty compliance work that some of us on this briefing are doing, but you know, what can we do about sort of the message that comes in the media after the Supreme Court decisions are released, and the message that we want to, you know, the human rights frame that we want to give to these decisions, and the message in our own advocacy. You know, so sort of what more can we do as human rights advocates to help translate from the Supreme Court decisions to the media, to the advocacy that we're doing, both with local and state officials, individuals, and the U.S. government. Do I make sense?
Well, I can answer that, I guess, from just thinking about Hobby Lobby and from the perspective of a human rights advocate. You know, we've really tried to reframe the dominant narrative about what this case is about, which, you know, the court would like it to be a religious exercise case, and we, along with other women's rights allies, have really tried to shift that into a discussion about women's rights, and more specifically, you know, thinking about the tagline, "Not my boss's business." So shifting it to where Justice Ginsburg would like this decision have gone, and many of us would too, obviously, where the discussion, where, you know, the starting point is really on women and women's fundamental rights. And when you have any kind of issue that involves a balancing of rights, that we need to have, like, at least a starting place that we can all agree with. And so that's, I mean, when it comes to the response, the sort of the response to the media, I would say that we are just trying to use human rights and women's rights and refocus that narrative in as many ways as we possibly can.
Thoughts from Rita or Katrina or Bob?
Question. I think it's hard to have a consistent message on this sometimes, or at least a consistent message even within the human rights advocacy, more pragmatic information around for folks who are doing advocacy, and message more and as for the public, it's important that while not like it, is really very focused on preserving a very strict balance between federal and state jurisdiction, and is going full force with its federalism jurisprudence.
Risa, we're losing you. You're going in and out. And now okay.
Now she muted, I think. Yeah. You know, I guess I would say, I mean, part of me thinks that since the decision I was talking about was a victory, one might say the less said the better. But a little bit less facetiously, Justice Kennedy, in particular, wrote in this opinion, despite all the kind of math that he was doing and looking at what the states did, talks about, you know, standards of decency and what a civilized society stands for. It does seem to me that one of the things that one can do is to point out how those values are not only just U.S.-based values and a kind of U.S. exceptionalism, but are really human rights values. So that this notion that we see out there that, you know, the United States doesn't want to be bound by anybody else's views, that we don't want people telling us what to do. It's almost as if the country has the kind of boss view that we were talking about earlier. I think is wrong on substantively. That is, it's a part of, and we certainly see this in the CRPD, that a lot of the values underlying the CRPD are quite consistent with the ADA and other kinds of U.S. laws that uphold the rights of people with disabilities. So many of us would say those are connections that should be talked about and should be emphasized, even as some opponents of the treaty say, well, we don't need it because we already have it. So I think the more that we can kind of fight back against those kinds of things. I will say that with regard to the Bond case, that I thought it was very good news that, because I thought Bond was a kind of a red herring with regard to the CRPD. I'm sure many people did, but that once it was decided, that immediately some of the Senate sponsors, Democrats and Republicans of CRPD ratification, came out and said, okay, this takes away that issue. Let's go for it. So I think there was a sense that people were watching those decisions and trying to move on them and not ignore them, because at least in the minds of some, they were relevant.
And I'd actually like to add on to that too, because I think you make a really good point that when thinking about how to cite to international law with the Supreme Court, I mean, there has been kind of a gradual retreat, I would say, since Roper from citing to international law, certainly on Justice Kennedy's part, and I think he's faced a lot of attacks. The Supreme Court has faced a lot of attacks for that. So what we've tried to do is really just integrate those arguments and the principles, the international legal principles, into our arguments before the court. And even with this brief, really showing how the consensus of the world community and among international law is really to support, as you said, to support what the court has already said with respect to free exercise claims. So showing how it's really consistent, and that the last thing we want the court to do is to take this radical departure that no other court or legislature around the world has done in recognizing the right right to religious exercise on the part of a for-profit corporation. So we were trying to show, this is so far outside what has been done before, and the U.S. doesn't want to be the outlier in that respect, as opposed to talking about it, framing it as the U.S. will be in violation of international law.
Right.
Well, I want to thank our speakers again, and thank you all for participating. It's a great discussion, and we'll have another one of these hopefully again next year, but let's continue these conversations about human rights implications of the Supreme Court decisions, and thank you all again for your patience with our technical difficulties as well. Thanks, everyone.
Bye-bye.